corporal punishment go away. People like Dr. Morrison are going to work towards that, I'm sure. But, as we know, the court said it's okay. The Supreme Court says okay. Here's what the Eighth Amendment says. I don't know if you wrote down the Eighth Amendment. It says, excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. Chris, who does the Eighth Amendment speak to? The people? All people? All Americans?
Citizens, yeah.
Citizens? Okay. Stephen?
Pertaining to prisoners.
Prisoners, yeah. It's all people, but it's all people who have been arrested. That the bail that is set for them shall not be excessive. I told you a story about my friend Brian when he was arrested, and the posted bail is $100,000, but you could put down 10% and be released on your own recognizance. Yes, Madison?
If you're found innocent, does your bail become reimbursed?
Yes, reimbursed. It does not go just into the state coffers. So excessive bail shall not be required unless there's an issue regarding flight risk. Oftentimes they'll confiscate your passport from you so that you can't flee the country. And there are some wealthy people who might own a private jet who they say, well, that person's a flight risk, you know. Let's raise their bail to keep them in jail. But again, if they're really rich, you get the bail of $1 million, it won't make much of a difference. Nor excessive fines imposed. That goes to the idea of if you commit a crime, a speeding ticket. Speeding ticket for doing 55 and a 45 should not be $1,000. You know, that they have to be reasonable fines, nor cruel and unusual punishments inflicted. And this is really what we're going to get at here. This, as Chris and Stephen have pointed out, it's directed towards criminals convicted of a crime. This has nothing to do with students in school. The Eighth Amendment, as the court found in Abraham, doesn't apply to corporal punishment in schools. You might go, wow, like, so the school can do anything? No, the school can't do just anything. Does not apply to students in school. All right, let's look at Abraham. You got your notes on Abraham? Take those out. Chris, did you get a chance to read Abraham? How you doing? Okay. What was the school policy in the school district?
That you're allowed, you're allowed to give corporal punishment. Like principal, which was right, was able to gave out like 5 or so licks of the paddle, but he ended up injuring Ingram and then another student in Austin. Hurt, like gave like Austin a minor fracture. Ingram, he couldn't sit down for a while.
Right, exactly, yes. You told me more than I wanted to know, but you're absolutely right. Ingram was the student who was subject to this school policy, and the policy, did it specify what kind of punishment should be meted out? Did it say anything about the number of licks? Was it unlimited? Did it say who could administer it? It said something about reasonable, right? Now, what do we know about reasonable from this case? So remember how do they define reasonable in this issue, in this case? It's a huge part of this. Aaron?
1 to 5.
1 to 5, right. So it was 1 to 5 licks, as they called it, with the paddle. And it would be administered by who? The principal, or it said something about the teacher in charge of the school, which I guess maybe there were some instances where schools didn't have a principal, so a teacher would be in charge.
How hard can they, that's generally pretty hard to break a bone in 1 to 5
If
hits.
they're breaking bones,
Well, he hit Ingram in 20. So
Oh yeah, so he like broke through with his finish.
Yeah, and there's, if after there have been subsequent cases, there have been cases that, they haven't gone back to the Supreme Court yet, but there have been other cases in the courts of appeals across the country since Ingraham that have told some pretty horrid stories about what we call excessive
In
force.
Abraham, they said it was like 16 kids who complained about the pattern.
Right. Yeah, the school had developed this reputation as being kind of a harsh place. Yeah, exactly. Was this a local law, Brendan? Was this a state law? Not sure? Does anyone want to help him out? Local or state law? Dave, you scratching your head or is that you there? Do you know the answer to this? Okay. Aaron?
It was Dade County.
It was Dade County, Florida, okay? But the state of Florida had passed legislation, so it was a state law. It was being applied in Dade County. How many licks was standard again? 1 to 5. How many did Abraham get? 20. Were they administered by a math teacher who didn't know math? That's quite a difference, right? Todd?
But like, Wright didn't even get in trouble from his school district, he got like just transferred, so why, did they not like challenge it on the basis that he didn't do that according to the school district rules, or?
Why wasn't Wright reprimanded?
Yeah. So why didn't Ingraham challenge what he did? Like,
What, I mean, that's a good question.
because he obviously broke the school district code, Palin has said 1 to 5, he quadrupled it.
Right. I don't know. That's a very good question. Sam?
Was it like another rule of law that it had, like, it results in no parent physical injury of each student?
Say that again?
Was it like one of the like, rules of this that it results in like no parent injury to a student?
Yeah, the paddling is not supposed to produce a significant injury.
But it did.
Huh?
But it did.
But it did.
So,
And it's, again, we come down to this question of reasonableness, like, what had Ingraham done that was so outrageous that he deserved this kind of punishment?
The hospices.
Yeah. He was slow to respond to his teacher, right? Could that have been a developmental issue? Or was it just that he was
Tired.
tired, lazy, didn't hear the instructions? I don't know. But as somebody did point out, it seems like the school's been given a fair amount of power in this case, to determine what is reasonable, determine that Ingraham's response time was inadequate. Anyhow, so Ingraham suffers this punishment. How was it given out? Eli, do you remember how it was applied?
Maybe across the table and put the pad on. Was it laid across the table?
Yeah.
Yeah.
Imagine that, okay? You laid across the table, and he was held down, if I'm not mistaken, right? I think it's something about him being held down. And then he was paddled.
But it's not punishment.
What was that?
But it's not punishment?
Well, it was punishment. It certainly was punishment.
cruel and unusual.
But was it cruel and unusual?
Well, wasn't there argument like it wasn't punishment because they weren't prisoners, so they couldn't?
Well, I don't recall if the court actually says it wasn't punishment. It serves, here's where the court's decision is. It serves an educational purpose in the court's understanding, okay? Because the court, how do they begin their discussion? Where do they begin their discussion? Do you remember? Chris, do you remember where they began their analysis of the case of this? Ryan, do you remember? Hmm? Eli?
Well, I don't really remember, but I just have something to add to the punishment. He said it was a punishment. You're saying that the cruel and the age limit only applies to inmates. So you're saying if I signed up for a job at Chick-fil-A, but then they said, okay, well you're signing this contract, but in order to work here, if you ever drop something you're making on the floor, something like that, we're gonna take you in the back and we're gonna like stretch you out of a portion machine we have, then they can perfectly fine do that, because you're signing up for it,
Do it.
and it's not a criminal, they can
No,
actually do that.
Because what's the difference between Chick-fil-A and the US government?
So that's probably it.
Chick-fil-A's a private corporation.
So.
You can choose to work there or not, you know, you can say their rules, they are out of their minds crazy. And you say, I'm not working there, you know?
There are other laws that like this can break, right, that aren't like constitutional?
This could, yeah, you could bring a civil suit against Ingraham. But again, a lot of what's gonna happen in that civil suit would hinge on what the court says, what the Supreme Court says. Just like in the OJ trial, OJ Simpson was not found guilty of murdering his wife, but he was tried in a civil court and found guilty of committing other crimes. Todd?
Okay, so like reading this, like yeah, on the case, it says like the school child doesn't need protection from the Eighth Amendment because even if things is mandatory, school is an open institution.
Right.
But it said the child is not physically restrained from leaving school during school hours, and that's not true. Like if I tried to just run off the school hour, I would attack.
Well, yes. Mr. Robert probably would.
Yeah, so like.
But you know what, here's where I think the court, if your parents write a note saying Todd needs to leave school, school can't say Todd's gotta stay. So again, if you're 18 years old and you're in high school, are you free to leave?
I mean, I can sign myself out.
You can sign yourself out, right? Okay, yeah. So, again, but if you're of the age of majority, you can sign yourself out. I got a doctor's appointment, boom, you don't need a parental note. But up until you're, I think, 16 or so, something like that, your parents are gonna be the ones who, if they wanna get you out, they can get you out. When you're in prison, if I was in prison on my birthday and my mom wanted to take me out for lunch, guess what? Her note would not do a darn thing. They'd say, sorry, Bill's in for a long stretch, he's gotta stay. Well, maybe we'll give him a cupcake with a candle on for his birthday, but he can't leave prison, all right? So yeah, let me get back to this point. How did the court begin the discussion? He began by looking at Eli.
What if a job that you had, if you held a state job,
Okay.
and they punish you, like physically, they physically punish you, you worked for them, and it
The
was a state
state
job.
did?
Yes. So like say, as a teacher, if you do something wrong as a teacher, like if you curse in class, or if you do something like anything.
It probably would not, you know what, they would be violating my rights on multiple levels. I don't know if it would necessarily be Eighth Amendment, because, I mean, if it was a punishment for let's say I was letting kids eat in class, okay? Eat food in class, and there's a school policy prohibiting that. You know, could I be taken out and disciplined and put on the rack and stretched or something like that, or whatever you imagine? No. That would be a violation of my constitutional rights, because they are a state actor.
Well then, but the teachers are state actors, so wouldn't that be a violation of our constitutional rights?
If I'm being punished?
Well, no, if we're getting corporal punishment, a state actor's.
No,
getting
because
it.
it's a different relationship, because I'm an employee. You're a student. It's a different kind of, much like the prisoner, just like the prisoner and the student can't be equated together, employees have a different status. We have an employment contract, which spells out certain things about how I'm expected to behave and so on and so forth.
So you're a student teacher now, right?
Right.
Right. So what if the school, or what if your college did that to you? Would they be allowed to do that?
Would they be allowed to, well, college is different, because college is a voluntary activity.
So they could?
No, because no one would go there, because you gotta pay money to go to college, and nobody in their right mind would pay money to go to college when you get
But
abused.
if college
Unless you wanna go into West Point or Annapolis, and then you accept that as part of your education, you know?
But they could if they wanted to.
I suppose they would, but don't quote me on that, I'm not positive. Okay, Ryan,
Does the superintendent, state tuition,
yes, superintendent
does
is.
he enact curriculum on student school visits?
If, in our case, if Dr. Morrison were to come in here,
Absolutely.
could he? Yeah, he could, but he never would.
Right.
I mean, it's just beyond the pale with him. All right, any other questions before we move on? I just want to get through anything right now. Okay. Court began the discussion by looking at historically the role of corporal punishment in the United States history. And said that it's a practice that's grounded in our colonial history. We've been doing this for 200 years. It serves an educational purpose. Okay? It's a part and parcel of who we are as a country. That's when they began their discussion. Does corporal punishment still play a role in public schools? I think we know the answer to that. Yes, it does. At least in 20 states it does. And then what was the common law principle governing corporal punishment? The common law principle is that it must be reasonable but not excessive force to discipline a child. Again, reasonable. We've come across reasonable in so many different cases. Think about the Fourth Amendment cases. Reasonable search and seizure. The reasonableness of drug testing in Potawatomi and in Vernonia. Okay? It's a vague term. But the court does provide us with some ideas of what reasonable is, but not excessive. So Chloe, I got to ask the question, is if the law says 1 to 5 licks, and someone gets 15, 16, 17, 18, 19, and 20, is that excessive? Okay? What if it's a really bad kid?
Okay, well, all he did.
What if it's someone who's really slow in responding to their teacher?
It's still excessive.
If someone's slow to respond.
Todd, get up! He's slow in responding.
I would get in so much trouble in school with a lot of paddling magic, so.
They'd be breaking paddles. They would have probably hanging up like in a
I'd
gallery.
be breaking paddles.
Schultz Power Room. Stephen, you were saying something?
No.
Ask
It's
an
not
answer.
really reasonable if he gets 20 just for being slow to respond to the teacher.
I wonder if I had a group of parents that I was talking to right now, how they would receive this. You know, I mean, if they were parents to think about, again, their child being disciplined in this way by the school. I mean, I acknowledge that there are times when the school has to discipline students. But is this the best way to do it? Court allows it as an option. What is to be taken into account when determining whether the punishment was reasonable? You recall what was to be taken into account? I think there was a list of 5 or 6 things. Lindsay, did you get that in the case?
Didn't they say like the seriousness of the offense,
Mm-hmm.
attitude and past behavior of the
Mhm.
child, nature and severity of the punishment, and age and strength of the child?
Mm-hmm.
That's all I got.
Okay, it's 4, and I think there's, I'll put it up here. You didn't get them all. The seriousness of the offense, as you said. The attitude and the past behavior of the child. Is he just habitually slow? The nature and the severity of the punishment. The age and the strength of the child, and I think the only one you missed was this last one. Availability of less severe but equally effective means of discipline. Is there another way that we could have done this? And of course, if you consider the way some of the other due process cases, that's always a question, is if the government's going, and again, it doesn't apply in this case, but is there another option apart from depriving you of your life, liberty, and property that the government has access to that they could use? Yes, Ryan.
Like my family used to live in Ohio, and I believe that it is legal in Ohio.
I think you're right.
One of my family members had corporal punishment against him. And
Really?
that severity, so, one day,
How long ago was this?
about 10 years ago.
Okay.
So it was,
I mean, one thing schools are good about now is making sure that if anyone has an issue like ADD, that the school is aware of it. And it should factor into any kind of disciplinary issue. You're not gonna paddle an ADD kid because they have a valid medical reason for, let's say Ingraham was slow. Well, 1975, I don't think we were diagnosing ADD, which is unfortunate because that may have been his issue, right? Stephen?
Says that he was slow, but what does the school consider slow?
Good question. We don't know.
Like,
I mean, hopefully the court had more facts, access to more facts than we have, but yeah, what is slow?
like I would understand if the teacher told him like 20 times to do something, and he's just
Right.
like, nah. But, I mean, if they told him like twice and it took him like, if they said like, get up and write something on the board and it took him 30 seconds to do it, then that's not very reasonable.
No, it wouldn't be reasonable. There's got to be, again, there's got to be more to this story, I would hope, to inflict such a harsh punishment. Everyone have these? The question before the court. Does corporal punishment in public schools constitute cruel and unusual punishment, and therefore violate a student's Eighth Amendment rights? And I think you all know what the answer to that question is. Patrick, let's answer that question. No. The Eighth Amendment, according to the court, does not apply. The Eighth Amendment does not apply to paddling of children as a measure of maintaining discipline in schools. And I think that's really the key here, because someone pointed out, or a couple of you pointed out, the message behind the paddling is that it serves an educational purpose. As strange as that might sound, much like the motivation behind parental discipline is to educate the child, so too with paddling in public schools. It's supposed to be a means of maintaining discipline and order, because that's always one of the issues the schools are wrestling with, is maintaining a sound educational environment. That's why in the drug testing cases, they could drug test. That's why in TLO, they could look in her purse. They're trying to maintain, schools are trying to maintain a sound, positive educational environment. And the court said that paddling is one of the means of discipline that goes to that end. It's a means to that end. Does that make sense? I mean, Brooklyn, does that make sense to you, in your understanding? Does it make sense that paddling would be a sound means of maintaining discipline in schools? If the court says so, then we're bound by that, aren't we? I mean, but states can choose whether or not to have corporal punishment or not. I mean, it's not as if the federal government said, therefore, all 50 states have to enforce corporal punishment. Again, we have this policy, we have this order called federalism, which allows the states to make a lot of these decisions on their own. So we have 20 states now that allow for corporal punishment as a means of maintaining discipline in public schools. Here's this little discourse here on the prisoner, differences between the prisoner and the school child. Since this has come up once or twice, let me just run through these if you want to write some of these down. Again, the prisoner is incarcerated in prison, which is brutal. Only unnecessary and wanton infliction of pain constitutes cruel and unusual punishment. Again, speaking only of prisoners, wanton and unnecessary infliction of pain. I mean, there is discipline that goes on in prison, which is pretty harsh. And it's supposed to not be wanton and unnecessary. One of the worst forms of punishment in prison is solitary confinement. The courts have found solitary confinement is not wanton and unnecessary. It does serve a purpose, even for prisoners. Schools are open institutions and monitored by the community. One of the great regulators on schools is the fact that there are school boards who are elected by the local community. The school boards have oversight over the schools. They review the policies, they draft the policies that the schools are bound by. That's why, we don't have corporal punishment, as you know, but if a teacher were to inflict corporal punishment and it was deemed excessive, they'd be gone. They'd lose their job. The school board has oversight. Student brings the support of family and friends. That's another way that they're different than prisoners. this is an open community, and you're supported by your family and friends, and that you have civil and criminal laws to protect you in school. For example, if you were subject to corporal punishment and it was excessive, you could sue. You have legal remedies to sue the teacher or the principal who inflicted that pain on you. If it's deemed excessive, of course. If it's reasonable, you just got to deal with it. The law that came out of Ingraham, here it is. Because of the history of this country of corporal punishment in the schools, that's when they began their argument, was by looking at the history. Because of the history of corporal punishment in schools, and the overwhelming majority of cases associated, the protections of the Eighth Amendment with prisoners, corporal punishment in a normal school setting shall not be afforded protection under the Eighth Amendment. That's what you got to remember about Ingraham, is that it's not an Eighth Amendment case. Students aren't prisoners, and the court believes that this method of discipline serves an educated purpose and is a reasonable means of maintaining order in the classroom. Because as I look at things, you're probably going to have a quiz on this early next week. Gary.
So, they said that it wasn't cruel and unusual punishment, but then they established that it was only reasonable if it was 1 to 5?
No, the reasonableness did not, reasonableness is really left up to, again, you have to look at those guidelines they provide on the other slide, like, you have to look at the severity of the offense, you have to look at the age of the student, like, Florida set 1 to 5 as a guideline. They could have set it at, they could have removed that number and said, based on the severity of the crime, based on, they could have gone that route, but they went with 1 to 5, because they were all obviously pre-Ingraham. Let's see the other hand go up. But yeah, we're bound now by this notion of reasonableness. Right.
So, like, those high school students, those college students, are they like,
I think it's younger kids. I think. You can look that up. I think it's mostly younger kids. Because again, just the idea of doing it in high schools, where you're all older and everything, it doesn't make a lot of sense to me as a teacher. There's better ways. Kyle's acting up. There's better ways for Kyle and I to address that than to me to try and, give him a spanking. I can say, listen. Right? Let's talk about the class. As opposed to like, hop up there, you know the drill. That would be just bizarre. Ineffective, I think. If I could give you a fact pattern, get you to the groups. All right, here's what I want you to do. Get into your groups of 6. We'll give you 2 fact patterns. And with our remaining time, what you're going to do is work for those 2 fact patterns.
Yeah, I would need to.
Brenda, how long are you fixed for? I get off work at 8:30. I'll walk around. Maybe. We all have. I want you to come hang with me, Brendan, after work. After I get off work. Where are you going? I don't know. I'll probably Daniel eventually. I really want to. Only problem is
All right, let me get up here.
Last time we done with Daniel, he was helping Brittany.
Daniel almost killed me.
Really?
And then,
When? Probably just think about a month ago.
I'd like to thank you first.
And like of all people, to say that, you say that to Daniel. Would you follow Daniel? Exactly. I wouldn't need to. And you know when the phone is going to be for a while. He's going to know somebody. Yeah. Takes a look. Yeah, I have knife to bro. I know.
Okay.
Even if you have a problem with him, you just don't bring it up.
I mean, I'll like rip on it and just
Just cut it.
Here is your fact pattern up on the board.